Hey, everybody. Hey, long time no see. Welcome to True Crime Wednesday. I'm your host, Lori Hellis. I'm a retired criminal attorney and the author of Children of Darkness and Light, the story of Chad Daybell and Lori Vallow. And we have just a lot to talk about. For those of you who didn't catch our live last night, Lori Vallow was found guilty. And one of the things we're going to do today is we're going to take a look at her closing and do a little analysis of how she did. We also have some things to talk about because Karen Reed is in the thick of it, as well as a few developments in Cobberger. So we've got lots to talk about. So welcome, everybody. While we're getting caught up, please remember to like and subscribe. Please pop out and hit that thumbs up button. It really does help the algorithm. So yeah, Lori Vallow represented herself and was found guilty yesterday of conspiracy to commit murder for the murder of her fourth husband, Charles Vallow. The jury found that she conspired with her brother, Alex, and that as a result, they attempted to make it look like self-defense, which it was not. And the jury found that she was guilty. So, hi, everybody. Nice that all of you are coming along. Hi, Ladybug Lady, and hello, Susie. Good to see you. We saw you yesterday. Hi, I don't recall. Nice that you're here. Glad you made a live. And I don't recall and I were talking last night about lawyering. They are a lawyer as well. And so we were talking about all of the ups and downs of lawyering, of learning lawyering, which is always a busy, steep learning curve. And so nice to see everybody tonight. Well, let's dive into taking a look at Lori's. Hang on here and let me get my screen up. Let's take a look. I'm going to share my screen and we're going to take a look at Lori's closing arguments.
Ladies and gentlemen of the jury, the state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit premeditated murder of my husband, Charles Vallow.
So let's talk about that so far. She is accurate that the state has the 100% burden of proof, but they don't have to prove 100% that she's guilty. Reasonable doubt is somewhere between 90 and 100%. So that's a little deceptive. I think she was hoping to sort of shade it. Maybe somebody on the jury would think, oh, well, we have to be 100% sure she's guilty. So, and once again, she is calling Charles Vallow her husband, even though her current husband and the person who she's been wearing her hair tie wedding ring for is Chad Daybell. So
the state has the burden of proving to you that this event was not self-defense.
Now, this is not correct. She is wrong on the law. When you make what is called an affirmative defense or a justification defense, the burden shifts to you to prove the element of self-defense. So, even though the state still has the burden to prove beyond a reasonable doubt that she committed the crime, the burden shifts to the defendant having to prove the issue of self-defense. So she's wrong on the law there. It is not their burden to prove self-defense. It actually is hers. And she didn't do much to prove self-defense.
In your jury instruction under the instruction, use of force and crime prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty. In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails.
I'm not so sure she's making points by repeating the jury instructions over and over, but I don't suppose it does any
To
harm.
carry this burden, you must find the defendant not guilty. Under your jury instruction titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction under presumption of innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty.
So I'm not sure that she's, I mean, I don't know that closing argument is the time for you to just repeat the jury instructions, but I think that's all she really knows how to do. So, and I want to say welcome to Jana Stenberg, who is here from Finland. Welcome. She says it's 4 a.m. there. So thank you for joining us. Okay, let's move on here.
In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial. We learned that a shooting occurred and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911. And
I sped this up a little bit because she's kind of dragging. So if it's too fast, let me know in the comments and I'll slow it back down again. But she's kind of taking her time. So
was questioned by the police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the stand that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her.
Hard to understand why this is relevant. Whether or not they got Tylee's medication doesn't seem overly relevant, and why she's bringing that up in closing arguments is a little hard to understand. And once again, she's just reciting the facts. So the important part of closing argument is the time to synthesize the facts and the law, to be able to say, as you saw when Trina Kay gave her closing, here's the fact, and here's what we had to prove. Here's the fact, here's what we had to prove, and here's the fact that proved it. Here's what we had to prove, and here's the fact that proved it. That's not where Lori's going. You know, she's doing her best because she's not a lawyer, but we'll see if it gets any better here.
We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
The jury will determine what the testimony did or did not show.
So this is the first place we get she draws an objection from Trina Kay. And you're going to see this several times. For the most part, when you have two lawyers who are doing closing arguments, unless one of the lawyers strays very far from their story and from the evidence in the case, you won't draw objections. It's kind of considered a little poor form, maybe, to object um, to openings and closings, as long as they stay on the rails. The problem here is that Lori's going off the rails. She is arguing things, facts that were not in evidence. They were things that testimony did not bring out. And now she's trying to argue them. So Trina Kay objects on several occasions. Now, I expected that she was going to draw some objections, probably because she was trying to interject objectionable information, but it also serves to throw Lori off her game. So let's keep going.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms, where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears. We heard from several witnesses that because this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, my police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inklin that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews.
Trina Kay is objecting here again. This is improper argument. Arguing about what the state could have and didn't show you is improper argument. And additionally, there were pretrial rulings about this. So the reason that it wasn't shown by either side is because, first of all, Alex's interview, both Alex and Tylee's interviews are hearsay because they're not here. Additionally, the judge ruled that Lori could not show Tylee's interview because she couldn't get the benefit of someone that she'd murdered. So she couldn't benefit from Tylee's testimony before her death. So it was definitely improper for her to bring those up and to say the prosecution could have shown you and they didn't.
Or let you listen to the 911 call.
The jury shall disregard that last statement. Okay.
So it's very unusual to have a judge strike closing argument and tell the jury to disregard it. Anytime that you have something that you're telling the jury to disregard, it's kind of like trying to put the toothpaste back in the tube. Now, most juries are honorable and really want to get it right. And if the judge tells them you can't consider that in your deliberation, then they don't.
The jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump and, according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the three of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited.
Lori really has made a lot from the beginning about the fact that they were put in touch with a victim's advocate. And I don't know that there's a whole lot that's mystifying about that, but Lori seems to think that if she was put in touch with the victim's advocate, then she must have been a victim and not under suspicion. The truth is that victims advocates often, in this kind of a circumstance where you have someone who's died, are going to help the family figure out details, figure out things. Charles's body was taken to the medical examiner, so it would be the victim's advocate who would help her figure out when the autopsy was done and then where what the next step would be in dealing with Charles's remains, because regardless of whether she was a suspect, she still was the next of kin for Charles and was the person who had the responsibility to make those decisions. So the simple fact that she was put in touch with victims advocates doesn't make her doesn't make her not a suspect. She can be a victim and a suspect at the same point. So, I don't believe she asked to speak to the victim's advocate. I believe that it's been a while since I've watched the entire interview, but I believe that Detective Inclan told her they were going to put her in touch, she and Tylee, in touch with the victim's advocate, because there would be things that she would have to decide. So
We learned that soon after that, all three of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all three of our cars were inside the police state. We were directed to return later in the afternoon when the scene was cleaned up. We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective Inclan to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case, on the stand, that because of some problem, the walkthrough is not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it.
So not everything that police officers observe gets into reports. I do agree that when they did the walkthrough with Alex, there should have been a report made. But it may be one of those situations where they thought the body camera was capturing what was going on, and so nobody wrote a report. I don't recall in his testimony him going in deeply to why they didn't record that. He just said, "We didn't," but it should have been recorded. Certainly, when you have somebody who the shooter who is actually walking you through what happened, that should have been recorded. And if it wasn't, then there should have at least been a report made, and they should have drawn a diagram so that they had a better idea of where everybody was standing.
We can infer from Detective Duncan's testimony and the fact that we don't have any body cam footage of the walkthrough and no reports talking about it, that there are none. even though this would be crucial evidence for you, the jury, to have.
Sustained. The jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony.
Right. So the judge is again saying you can't consider what the prosecution could have given you. I mean, if that were the case, the jury could go back there and say, well, how come we didn't see Tylee come and testify? Why didn't they produce uh, uh, this or that? And that would be improper. Yeah. I'm just gonna beat Jen to the and pull this question because I just spotted it. Is it improper to comment on what police didn't do in closing when the issue was litigated pre-trial and the court ruled against it? Absolutely, it is. But this would have been improper anyway, because it's simply improper to say to jurors, you could have gotten this and you didn't. And do you think Karen Reed's defense will be able to? No, I think Karen Reed's defense are really savvy, and I don't think they need to. They have so much. They are. I mean, man, we're going to get to Reed, and we'll talk about it. But I think they don't need to.
I'm sorry, testimony that was admitted into evidence or exhibits that were admitted into evidence.
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only 3 witnesses. So why not show the jury all the evidence that they gathered?
Again, sustained.
So she keeps trying. And it's interesting because even with her side view, just with her hands, and you can tell that she's getting frustrated that she can't say these things. Let's remember that Lori has this sense that she is above it all, that she is the goddess, that she alone can make these kinds of choices. So she's not very happy about having a judge tell her what to do. And as it goes on, she gets pretty frustrated.
The jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with.
One of the things that she does is she goes right back to her comments. She doesn't acknowledge the judge's rulings, and it's almost like she's shooing away a fly. She sort of doesn't count. So she's trying to minimize the impact with the jury of the judge's continuing ruling against her.
Law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019. That law enforcement treated us that day like this was self-defense. We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind. On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
I'll sustain that objection to the extent the jury is to determine what the facts did or did.
So the press release was never entered into evidence, and whether they put out a press release or not is absolutely irrelevant. Once again, she's getting into facts that aren't in evidence.
Did not establish.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense. This event was not planned or expected. It was shocking. We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue.
This is not a horrible tactic. This is not, it's not terrible that she's arguing. I think it's always appropriate to go after any missteps in the investigation, any deficiencies in the investigation. So it's not a terrible argument, but I think that it sort of puts the jury in the position of going, well, duh, Alex said he was the shooter. Why would police think that they needed to swab anybody else for gunpowder residue? But it's not a horrible argument in terms of trying to point out deficiencies in the investigation. And she is arguing things that were in evidence. So these are proper arguments.
Residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene.
Now, I agree that not searching the rental car was a big mistake. That was a misstep in the investigation. Knowing that Lori had been driving around in that car, knowing that Alex had been in the car, I think it would have been appropriate to search the car. One of the things we don't know is where Lori's shoes went. Apparently, when she went in to buy the flip-flops, she had shoes on and swapped out her shoes for flip-flops. So where were her shoes? They had plenty of time while she was driving around and plenty of time afterwards when they left and went to Alex's in that car to get rid of her shoes. Was there blood evidence in the car of Charles's blood that would prove that Lori was still there when the shots were fired and was in the immediate vicinity close enough to get blood on her shoes? We don't know any of those things because they didn't search the car. So I think that is a valid point.
They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was self-defense and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time, on July 11th, this was self-defense. When Tylee came out with a bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down.
Okay, so she's going to make this all about that Charles had a choice and could have put the bat down. She had a choice. She could have given Charles back his phone. But for 12 minutes, they danced around while she wouldn't give him back his phone. And she wanted to know what was in his phone. She made it sound, when she talked to police, like she was upset with him because she found evidence that he was cheating. Well, there may have been evidence that he was talking to other women. There certainly was evidence he was talking to Nancy Jo. However, I think the bigger question was she wanted to know what he was planning with her brother Adam in the way of an intervention. So, yeah, she's saying, well, Charles could have put down the bat. Well, she could have given him back his phone and defused all of this. But as the prosecution's argument makes the argument that taking his phone was simply a way to keep him there long enough for Alex to cause the confrontation, long enough for Alex to come out and shoot him.
A 2-minute period changed our lives forever.
2 minutes. She says 2 minutes. but prosecution says 12 minutes, and their timeline adds up. I mean, when you look at it, their timeline adds up.
How are you supposed to choose between three people you love? Your husband, your daughter, your brother?
All right, hold on. All right, I'll caution the defendant not to testify.
So this is an appropriate ruling because Lori is trying to get her side of the story out through her argument, and that is simply not appropriate. She's not allowed. This is a person who decided not to take the stand, not to testify on her own behalf. She had every opportunity to do that. She doesn't get to sneak in her testimony in her closing argument. And you know, you gotta wonder how much of this is Lori doesn't understand and doesn't know the rules, and how much of this is Lori pushing it as far as she can.
About things that were not entered into evidence.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
This is a really good point that the prosecutor makes, because the standard is if a reasonable person in a similar circumstance would feel threatened.
The reasonable person standard, not the standard person.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best thing for our son with special needs, JJ. We learned in this trial that I was shocked that Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband, Charles, was providing for our children still at home. I had no motive to change that. We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, we will be like Nephi. In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
Right. Sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is the state's attempt to misconstrue.
Let's take a listen to that objection.
Culture, Nephi signifies strong faith, perseverance, and courage.
Right.
Okay, she's once again trying to get in facts that are not in evidence, because nobody talked about Nephi and whether or not his story was one of strength and courage. We got a little bit from Adam, who talked about the actual story of Nephi killing Laban, but we didn't get anything about Nephi's character. So
Sustained.
The state's attempt to misconstrue the positive text message about a wonderful religion.
It's interesting if you watch her. I will say that the state of Arizona was particularly careful about and Court TV or whoever the pool camera was were particularly careful about the live stream, and that they didn't zoom in on her at any point. They very rarely even showed her face. So we can't see a lot of her emotions, but we can see her hands. She's pounding on the podium, which is clearly she's getting a little agitated. And we can see from her hands that she's getting kind of tight.
Just figure Nephi and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime. When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime. And you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened.
So, but she didn't, because she didn't testify. So the only thing they have is her interview. She didn't tell anybody just about how it had happened.
The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack.
Now she's making it personal. The state put forth evidence to make you dislike me, to attack me. So she's trying to say that this is all about the state trying to sully her character, which is far from the truth. Let's remember that if they wanted to sully her character, they had plenty to go on. They had plenty of ammunition that they did not offer. Excuse me, because they didn't want to be seen as piling on. And as they didn't want to be seen as offering prejudicial information that would prejudice her more than it would prove their case.
My character so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder.
So she's made this argument all along that they can't prove there was a conspiracy. I think they did prove that there is a conspiracy. No one saw with their eyes or heard with their ears her and Alex agreeing. But there's a lot of circumstantial evidence to prove that. So let's talk about circumstantial evidence, because she doesn't entirely understand it. So when we're done here, we're going to talk about circumstantial evidence.
They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy.
All right, the state does have the burden.
Okay. I want to say thanks to Court TV for our fair use of their video for educational purposes. So let's talk about Lori had a hard time with the idea of circumstantial evidence. I'm certain that the jury was given a circumstantial evidence instruction. They were also, Trina Kay also in her closing talked about some kind of layman's descriptions of circumstantial evidence. So here's the way I always think of it. If you have a jigsaw puzzle that you're putting together, and it's a puzzle of a garden, and you don't necessarily have a clear vision of where everything is, but you know that there are lots of flowers and that there are two sort of brown areas in this puzzle. One of those areas you start putting it together and you think, this could be a bench or it could be a dog. So you keep looking for brown pieces and you keep trying to put the pieces together until you get enough of the brown blob that you can tell whether it's a bench or whether it's a dog. Now, do you need the entire picture to be able to do that? No. If you know that this brown blob could either be a bench or a dog, and this piece has ears on it, pretty sure you're going to figure out that that particular brown blob is the dog. Same thing with circumstantial evidence. You're able to infer what something is or a fact by putting pieces together that lead you to that obvious conclusion. So you draw the inferences from the facts that you have to conclude a fact you don't have. So in this case, they were able to draw the inferences from the facts they had, from the text messages, from her text message to Chad saying it must have been Ned before we got rid of him. Chad saying, interesting to know if he changed his beneficiary after he had 2 bullets in his chest. Her sending a text to her brother Alex, who was the shooter, saying, I will be like Nephi and so will you. So the jury had plenty that they could infer, plenty of things that they could infer about that. So drawing reasonable inferences is part of how you put together a circumstantial case. So when all was said and done, the jury was out for about almost 3 hours. When I was on on Surviving the Survivor, Joel asked me how long I thought the jury would be out, and I said 3 hours. And as the clock started ticking, as we were watching it on the live feed, and the clock was ticking, and we were getting closer to 3 hours, I thought, uh-oh, I'm going to be, I'm wrong. And lo and behold, at 2 hours and 58 minutes, the jury said we have a verdict. So hard to be humble when you're that good, you know. Who knows, honestly. I mean, that was my guess, sort of based on what I know about juries, but I mean, we've seen juries go for a long time and then come back and convict. So, yeah, it's not a sure science, believe me. Thank you, Polio. Yeah, I'm that good. So I want to move on and talk about a couple of things that have come up in Brian Cobberger's case. We keep getting little kind of dribs and drabs as they're starting to work through all of these pretrial motions. Now, he comes to trial the end of July. I got to find my notes here. Because I can't remember if it's the end of June or the end of July. It's the end of July. Jury selection starts on July 30th. So now we're starting to see a lot of the pretrial motions, evidentiary motions. We're going to keep seeing those until trial, just as we've seen them right up until during trial in the Reed case. So one of the motions that the judge was asked to decide was the issue of his Amazon search history. Now, the defense does not want this in. The defense is doing everything they can to keep this out because it is very incriminating. So what the Amazon searches showed is that he bought a K-bar knife 8 months before the murders, a K-bar knife with a sheath and a sharpener on Amazon, that he tracked the shipment, that it was delivered to his parents' home, and that then he went in and tried to delete the history after he received the knife. He then later, the prosecution claims he made a later search after the murders for a K-bar knife. The prosecution claims that that was a replacement for the knife he got rid of because it was the murder weapon. So the defense has been trying to keep this out, and they've made a number of arguments. They made an argument that it was a family account, that you couldn't tell who actually did the ordering and what have you. The judge wasn't having it. And a couple of the things that we did learn from the judge as a result of this finding, excuse me, was the fact that the delivery was confirmed to his parents' home, and that he tried to delete the browsing and shopping history about the knife. Those are facts we didn't know. The other thing that the judge decided was that we're not going to, he was not going to allow the defense to introduce Brian Cobberger's autism into the conversation, and as a way to explain his reactions to things in court. So those were two things that that the judge did not allow. So there were a lot of really interesting things that happened today in the Karen Reed case. The Karen Reed case was incredible. And there were a couple of things that happened today that were sort of beyond belief. So I wanted to talk a little bit about it. I was just kind of pulling up, I'm looking at my phone actually while we're doing this, because, and you guys can probably help me out with this so I don't really need to be looking it up on my phone. Today's witnesses were one of the first responders, and also the police officer who downloaded the telephone. But the most interesting was Carrie, and it's her last name, I can't remember. She was friends with Karen Reed and Jen McCabe. Actually, she was not necessarily friends with them, but she got pulled into showing up at the crime scene, and later became very close friends with Jen McCabe. Jen McCabe is the sister of the homeowner. I think that, yeah, that's right, Alberts. Jen McCabe is the sister of the homeowners, and is deeply involved in this case from the beginning. So the most fascinating part of today was that in the original trial, in the first trial, which the jury was not supposed to know it was happening, but Carrie got up there and talked at length about what she testified to in the first trial. Carrie Roberts, thank you. So she really sort of let that cat out of the bag, as if they didn't already know. And but she also talked about her testimony in the first trial. She was not cross-examined in the first trial. I don't know why the defense decided not to cross-examine her, but boy, they made up for it today, because they went after her. They went after all her testimony. She's changed her story. She was one of the people who claimed to have heard Karen Reed say she hit John. I mean, they really took her to task. And so for those of you who are interested in trial practice and in the way that lawyers try cases, this case is an absolute textbook case. After watching Alan Jackson, the guy we all call Ajax, give his opening statement, I am convinced that he is one of the best lawyers of our generation. Absolutely. I mean, his opening statement was flawless. The Commonwealth's first witness was one of the first responders. He was also the guy who claimed to have heard Karen Reed say, I hit him, I hit him, I hit him. So Alan Jackson really took him apart. Adam Lally has really gone out of his way to use these bits and pieces of dash cam footage from the night of the morning John was found. He's using bits and pieces of video, and I don't think he's doing himself any favors, frankly. So Alan Jackson was then able to take that same video that it's not him, it's Brennan, Hank Brennan. Lally was last time's prosecutor. Hank Brennan was using all these bits and pieces of video, and Alan Jackson was able to take that same video and use it to impeach the officer. So he's a master at using impeachment evidence. So if you are interested in trial practice and how a good trial is run, he's your guy. Remember that. I don't recall. Yeah, Officer Nuttall was or Fireman Nuttall was the first guy. Then Kerry Roberts, and Kerry Roberts once again. It's a little hard to understand why Brennan is taking these witnesses in this order. It was a little confusing and a little bit perplexing why he was doing it, but we'll see. So the next witness was Kerry Roberts, and Brennan really, if you remember from the first trial, Jen McCabe got up and said, "Oh, Carrie's a talker." Well, she sure is, and I can't do a Boston accent, but that sounds more like Midwest. But she did. She got up there, and Alan Jackson just let her talk. He didn't raise a lot of objections, and he just kind of let her go. And when she was all done, he got up and he just dismantled her. If this is what is waiting for Jennifer McCabe, I can't wait. Bring your popcorn for that one, because we know that she wasn't truthful. And Jackson was really able to point out all of the places where she wasn't truthful. And at one point got her to admit that she had lied. She said that she heard something. Told police that she heard Karen Reed tell Jen McCabe to Google how long it takes to die in the snow. Today on the stand, she admitted that she never heard that she heard somebody tell her that's what Karen said. Yeah. So it was a masterful cross-examination, impeachment, essentially got her to admit on the stand that she'd lied. And that's as good as it gets. I mean, as a defense attorney, that's as good as it gets. So when Jen McCabe's turn comes, it's going to be a bloodbath, I'm telling you. So I'm here for it, because she lied 17 ways from Sunday. I think sometimes, yeah, I don't recall says, Brennan makes me want Lolly back. If I had to choose between the two, I'm here for it. I'm telling you, they're both weasels. I mean, Brennan has just turned out to be the biggest weasel. So he I hope that he's got that $225,000 or $30,000 that he's been paid for this case well invested, because his career is in the tubes. This is a career-ending choice, taking this case. So, yeah. So Alan Jackson had a real field day with that. We had a couple of other witnesses. We had Trooper Garino. Um, Hank Brennan wanted to bring in a third party, or a man and woman actually, to read text messages. He wanted readers for the text messages. Now, last time it was Trooper Garino. He was the cell phone guy that we heard from today, who read the text messages. And Alan Jackson and the defense team stood up and said, "Hold on a minute. This is a trial. This isn't a community theater production. No, you don't get readers." So, and the judge agreed. So Trooper Garino is going to be on and off the stand quite a bit to bring in the text messages. So Brennan wanted to do this, like introduce a video clip, introduce a text message, then put the witness on that would corroborate or reinforce that piece of evidence. And he had a whole plan. Well, it didn't go to plan because the judge said, "No, you're not getting a reader." So now he has to bring Trooper Garino in anytime he wants a text message read, because Garino was the one who did the phone extractions and actually put the report together of the text messages. So we'll get to hear Trooper Garino read all the text messages. So, I think that they're starting to move into some of the other law enforcement witnesses. It's not unusual for prosecutors to put in, John O'Keefe's mother was on the stand today. And that was hard. It was hard to see the prosecution put her on and ask some of the questions they did. It was difficult, and I thought there were places, I think, where the defense could have done some cross-examination, but they very gracefully, Alan Jackson stood up and said, "Mrs. O'Keefe, I'm very sorry for your loss. We don't have any questions for you." And that was a classy thing to do, because there's plenty that they can get in with other witnesses and in other ways. Taking it easy on the mother of the victim, taking it easy on his kids, those are going to be important to the jury, because the jury's going to be able to see, okay, this defense isn't going hard on people just because they can. So I think that was a smart move on their part. So will be interesting to see. I think it's not at all unusual. Don't be surprised if you see sort of more emotional witnesses in between some of the other more scientific witnesses. The judge is still intent on doing some voir dire for the ARCA witnesses. The prosecution is still insisting that the defense hasn't turned everything over, and the judge wants them there. They haggled about when they could be there. You know, these people don't live in the Boston area. So the judge initially said she wanted them to come in on Friday afternoon because the jury already knew that they were only going to have a half day. And the defense came back and said the ARCA experts are in a different matter and cannot be available. So they finally settled on Monday afternoon when they're going to bring the ARCA guys in. So we'll see what they have to say. But I think sometimes, as we saw today with John O'Keefe's mother sort of right up against the cell phone guy, because the cell phone guy's dry. He's talking about technical stuff, about gray bar and I think, I don't know, and Cellbrite and towers and sectors, and it's stuff that it's dry and it's hard to listen to. So to keep the jury's interest in, what the prosecutor is doing is saying, okay, every time I have one of these really dry witnesses that are talking about technical stuff, I need to bring the jury back to remembering why we're here, why they need to listen to this, because it's about John O'Keefe. So for each of those really difficult witnesses, he's going to try and offset that with somebody with a little bit more emotional appeal. So that's why today we saw Garino and John O'Keefe's mother. From a story standpoint, from a narrative standpoint, those two witnesses don't make a lot of sense being right up against each other. But from the emotional tone of the trial, they do make sense. So I'm ready to find out what kind of questions you all have for me tonight. We talked about Vallow. We talked a little bit about Cobberger. We were talking about Reed. So let me know what questions you have for me. And while we're waiting, please subscribe and like. Hit the like button, please. Polio, how is it that the whole Lori interview was given to the jury? What happened that it was only snippets? Did she find a loophole to get the whole interview admitted? So I do not recall there being a pretrial motion limiting the pieces of her interview that could come in. Now, what the prosecution did was they showed the parts that they thought were relevant. So they didn't show it all to the jury. But Lori had the ability to say to them, go watch my entire, because the prosecution did admit the whole interview into evidence. They only showed portions of it. That's not unusual. Sometimes what will happen is a defense attorney will say, hang on, if you're gonna admit those pieces, I want the whole thing admitted, and I want it published. I want the jury to see the whole thing. But in this case, Lori didn't do that. So she was free to direct the jury to go look at the complete interview. And I suspect they did, which may be why it took them 3 hours to reach a verdict. I don't think that I frankly don't think that Lori's interview did her any favors. It made her look strange. She was very composed. She was very matter of fact. And there is this period where Detective Inclan, Kylie and Lori were in 2 interview rooms, and they were literally right next door to each other. So on the tape from Lori's interview, you can hear conversation in the next room. You can't hear what's said, but you can hear voices in the next room. So Detective Inclan goes from Lori's interview next door to Tylee. You see her on Tylee's tape. You see her come in and have a conversation. Lori, in the meantime, is sitting in this interview room. She's in an overstuffed chair. She has her legs, her crisscross applesauce. She's sitting cross-legged in the chair. And she sits there, and she is so still that you almost, if you couldn't hear the voices in the room, you would think the video had been paused, but you can still hear in the soundtrack the voices next door. She is so eerily still. And it's only after this officer leaves that she at least acts like she's crying and grabs a tissue and dabs her eyes. And then she takes this deep breath and she sits up really straight like she's doing yoga. And she sits there absolutely motionless for many minutes. It's a little eerie. So I don't know that that helped her at all with the jury. So, but good question. Can you talk a bit about Lori's stipulations after the verdict? Sure can. Hi, Jane. I thought this was a little odd, frankly. So in Arizona, life in prison, it's not life without parole, but it's life in prison. There need to be aggravating factors in order for them to impose the maximum sentence. So the judge, prior to the closing arguments, said to both sides, I have to make sure that you guys agree on this jury instruction on the aggravating factors. If she's found guilty, the jury has to also decide these aggravating factors. So it's kind of like a death penalty case, not as extensive, not as, but there are these aggravating factors that the jury has to decide. So those stipulations, and I'm paraphrasing here, that the weapon was a dangerous or deadly weapon, that that the crime was committed with an accomplice or a co-defendant, and that the victim or the family suffered severe physical or emotional harm as a result of the use of the deadly weapon. So now all those seem like no-brainers. But so she stipulated, I think that it may hurt her if she decides that she wants to appeal. Because essentially what's happened is she's put on all this evidence saying, I'm innocent, I'm innocent, I'm innocent. I didn't shoot my husband. I didn't conspire to shoot my husband. And yet, when she gets to the stipulations for sentencing, it is, well, okay, it was a deadly weapon and I conspired with a third party. So I think that may be a little tricky if it comes to an appeal. But they were things that were easily going to be proven. I don't know why she decided to stipulate. Maybe she was just tired and said, I don't want to do this anymore. I just want to be done. I don't know. Because she come this far, it seemed a little odd. So I don't recall. I think it's easier to defend against a good prosecutor. Few sidebars, less arguing, more on point. Would love Lori's take on this. Yeah, I totally agree. I completely agree. The other thing that often happens in jurisdictions where you practice all the time is the prosecutor, the approach they take to cases. And you very likely have had some conversations with this prosecutor about how this trial is going to go. So you've done everything you can to sort of streamline those things. But you're right. A good prosecutor who is interested in justice and is not interested in win-loss notches, is a thing of beauty in a criminal trial and does make it much easier. The prosecutor can make or break the case. Let's put it that way. So, good question. I don't recall. You're going to have to get in touch with me. We're going to have to chat about legal things. Eat the food, Tina. I highly respect Ann Taylor, but some of her motions seem a bit over the top. As a criminal defense attorney, would you be doing anything differently? I tell this story. defense attorneys, sorry, I've been sitting on my butt too long and it's tired of sitting and watching trials. Defense attorneys know that there are arguments. We used to say, this is an argument that I'm going to have to put a bag over my head to go argue in court. And there were some times that somebody would say, well, you could always do this. And you just go, I can't do that. I'm not going there. But you know, when I was practicing, we had a lawyer in our consortium, our defense consortium, who had no shame about going to court and making those arguments. And every once in a while, he'd win one. And as a result, he had the best win-loss record of anybody in the group. So what I'll say in a death penalty case, I highly respect Ann Taylor too. And I will say about Ann Taylor, she knows this case inside and out. I think that she is doing everything she can for her client. Some motions are motions that you just make because it's the death penalty. And in a case where you wouldn't necessarily make an outrageous motion, you want to do it not because you think it's going to be granted, but because on the outside chance that it could be something that an appeals court could be interested in. The other thing is that you always have to make every possible motion to avoid an ineffective assistance of counsel finding at the appellate level. So, you know, it's really hard for the appeals court to make an ineffective assistance of counsel finding when they're looking at the record and saying, well, I just don't see that there is anything that your lawyer could have filed that they didn't file. I mean, they threw it against the wall to see what would stick. And that is sometimes what you're forced to do when it's a death penalty case. You know, the Supreme Court has said death is different. And what they mean is that death penalty cases, they expect more from defense attorneys, more arguments, more digging deeper into the facts, digging deeper into motivations. I mean, the courts just expect that. So I think she's doing everything that she has to do. That doesn't mean that she isn't, upon occasion, thinking she's going to have to put a bag over her head to go make that argument. Now, what bothered me was in the last group of hearings that we saw, one of her co-counsel brought a couple of motions on 403 and 404B evidence, and she was just wrong on the law. Now, I don't think she's got any business going to court and making those kind of motions and just standing there and being patently wrong on the law. That's ridiculous. Going there and trying to convince the judge the law is something it isn't. I think that's unprofessional. So I don't know why that happened, but there were two different motions that she argued having to do with 404 and 403B, or 404B and 403 evidence. For the uninitiated, 403 evidence, 403 Rule 403, evidentiary rule 403 says that even evidence that's relevant can be kept out if it's more prejudicial than probative. And 404B specifically talks about character evidence and the evidence of prior bad acts. So bringing in a prior bad act to prove that the person acted in conformance to their character. You can bring in a prior bad act, as they did in Lori Vallow's trial when they brought in Charles Vallow's death. You can bring it in to prove motive, to prove planning, to prove that there was a prior plan, to prove collaboration, a bunch of other things. But you can't bring it in to say she murdered somebody and so she must have murdered this person. You know, she murdered Charles, so she must have murdered Tylee and JJ. So that argument, when it came in, she was arguing that she wanted to keep out the traffic stop that happened earlier in the year. Now, we've seen video of a traffic stop that happened while Brian Cobberger was driving with his father back to Pennsylvania. That's not what they're talking about. Several months before, Brian Cobberger was stopped in a traffic stop for, I think, not wearing a seatbelt, if I remember. And they wanted to bring that in. Well, the prosecution said it proves that he drove a white Hyundai Elantra, and it goes to identification. And the defense attorney was not Ann Taylor, it was one of the other lawyers on the team, came back and made a pretty ridiculous argument. And the judge kept saying, you and I have a disagreement about what 404B actually says. And he pushed back a couple of times. And when she kept making this argument that made no sense because she was wrong on the law, he finally said, well, we're just going to have to agree to disagree, and I'm going to deny your motion. So that I found a little troubling. But as far as Ann Taylor goes, I've been very impressed. She's very fast on her feet. She's very conversant in the law as well as in the facts of her case. And that's what it takes in order to be that caliber of lawyer. You have to have this broad, it doesn't happen when you've been practicing law 2 years. It happens when you've been practicing law 20 years. You know, we talked last night about what it's like to practice law. And I said, one of the things that I loved about practicing law was every day was different. I learned something new every day because the way the law applies to a certain fact in a certain case is completely different than the way it might apply in a different case. I loved that about the law. But I do know that there was the point in my career, and I can't even tell you when it happened, but you know, maybe 10, 15-year mark, where I remember a colleague asking me a question and me answering it without even a whole lot of thought and thinking, wow, I do know my stuff. And I think that was one of the first times where I came away thinking with a larger sense of confidence about my experience and my knowledge of the law. But I have said all along, the law is, you will learn something new about the law every day that you practice. You're never done learning. It's too vast. There's too many specialties. There's too many things. I mean, there's so much I don't know about business law. Do not ask me about the Uniform Commercial Code because I haven't looked at it since I was in law school 30 years ago. So, you know, everybody is different in the way they approach practice. And it does take time to get to that point of thinking, okay, I feel proficient. Because I'm not sure you ever feel 100% proficient. What else you got for me? Hi, Flashback. This is a good question. A Vallow juror let it slip that he knew of Lori's 3 Idaho convictions prior to deliberations. Can this post-verdict revelation cause a mistrial or other problems? So it's possible that it could, but here's the question. Did that juror share that information with all the other jurors? So if the judge is asked to inquire of the jurors about this, the 2 questions the judge is going to ask is, did you tell everybody else? And I would say it's unlikely because the judge had said, don't bring in any outside information. You can only deliberate on what you heard in juries in the case, and you can't talk about the case other than to deliberate about the evidence that you were presented with. So it's unlikely that that person shared that information. Then the second question the judge would be asking that person is, did that impact your decision, your deliberation, and the way you decided the case in this case? So it would be a fairly high hurdle, I think, to get over. If the juror says, I didn't tell anybody, and if the juror says, I feel like I was able to decide this case based on the evidence that was presented to me, then I think a judge would say no harm, no foul. And I had to say from the beginning, I thought it would be very unlikely that nobody in the jury room would know what happened to JJ and Tylee. But I think that for the most part, the jurors didn't know. And I wonder about how they're going to feel about this case, knowing that. I'm sure that they will feel a little angry that they weren't told that it would have been nice to know, even though we believe that we don't want juries prejudiced by that kind of information, even though the system discourages prejudicing juries with that kind of information. So I wouldn't blame them. I think that it would have been more devastating had they acquitted Lori and then gone home and discovered that she was responsible for the deaths of 3 other people. So I haven't heard a lot about the other jurors, but I'm sure that as the weeks go on, we'll hear more from the other jurors. We sure did in Lori's trial. And in fact, Tom Galvin, who was one of the jurors in Lori's trial, he was an alternate, he didn't deliberate, has been making the rounds on some of the YouTube shows since for this trial. So I was actually on with him on STS, and we talked about how it feels to be on a jury and maybe have that information withheld. If you remember, the jury in Lori Vallow's case was not told that Lori Vallow had been indicted in Charles's murder. They were told about Charles's murder, but they were not given any information about her being indicted in the case. Yeah, so they didn't know she had charges pending. Jane Blackbird, can defendants represent themselves on an appeal? If so, are they given access to legal counsel? Yes and yes. People can, just like they can represent themselves in trial court, they can represent themselves in the appeals court. So it's less likely in the appellate arena, and here's the reason. Although Lori has been complaining about her appeals attorney in Idaho, I'll get to that in just a second. When an appeal is filed, it is we say it is filed on the four corners of the transcript. Okay. What that means is that the appellate court isn't a retrial. The appeals court is going to take a look at the trial as it happened by reading a transcript of the trial. And they're going to determine whether or not the trial proceeded properly. So they're going to be looking at issues such as whether or not Lori's speedy trial rights were violated, whether or not certain objections shouldn't or certain exclusionary decisions were right or wrong. They're going to be looking at the legal technicalities, not at the fact finding, because appeals court, when a trial happens, either the judge or the jury are determined to be the finder of fact. In a jury trial, it's the jury that decides the facts of the case. What happened, what's true, what's not. They're the finder of fact. In the case where there's not a jury, say a defendant has opted for a bench trial, so they've opted to have a judge act as the finder of fact, then the judge does that. And what the appeals court says is, we're going to assume that the finder of fact at the trial level had the best opportunity to gauge the credibility of the witnesses, because the finder of fact was there to see the person's mannerisms, to hear their voice, to listen to the testimony. And we're not going to second guess that. So the appeals court is going to be looking at, was the trial conducted properly? Did the trial court make the proper rulings? The trial court is not going to go back and say, well, we're not really sure that the jury should have believed Trooper Proctor, or we're not really sure the jury should have believed Chad's kids. Because that jury is not going to get into the credibility of any of the witnesses. So on appeal, it's often more likely that you would have an appellate attorney do an appeal, because appeals attorneys understand appellate law, and they're the people who would be the best suited to write an appeal. Lori doesn't get to put on any new evidence in the appeal. I think that's something she's having a little trouble understanding in Idaho, but she doesn't get to add anything to this. They're just going off the transcript. So it's more likely that she would ask for a court-appointed appellate attorney, I would think. My understanding is that she's frustrated with the fact that her appellate attorney isn't having a lot of contact with her. I've also heard Sarah Boone is also very frustrated with the fact that her appellate attorneys aren't communicating with her enough. And in both cases, I think they both want control over a process that they don't get any control over. So good questions, guys. What else you got? Susie Gay was saying, let's see what Susie had here. They were asked if they looked her up, and they said as soon as they were released. To me, he was saying they knew right after being released from the admonition. Well, that might be because the one juror who knew may very well have told them once they were released from the admonition what he knew. And that would be appropriate. I mean, it would be perfectly acceptable and appropriate for that juror to say, by the way, I knew this and I couldn't say anything, but that would certainly be the appropriate way to handle it. Catherine, I saw 3 jurors interviewed. None knew about the previous conviction until all the jurors were told after they were dismissed. What juror she said they knew about it ahead? I don't know. I haven't seen any of your interviews with any of the jurors, but somebody said that that one of the jurors was aware of the Idaho murders. So, and it may be that one of those jurors spilled the beans after they were dismissed. So I don't know. I haven't seen any of the interviews with jurors yet. I've been too wrapped up in Karen Reed. Holy cow. Man, oh man, those lawyers, there's something. You know, I mean, their trial skills are amazing. And, you know, now I will say they have been living with this case for years. You know, they have been living and breathing this case for a long time. And that certainly contributes to knowing the facts of your case and being conversant in them. But I mean, the preparation, when you watch Alan Jackson's cross-examination of Carrie Roberts, I mean, you know, and you watch his opening statement, and it is smooth and it is practiced, and it is I mean, he's been working on this opening statement for weeks, because it was perfection. So yeah. And it makes it fun for me to watch a trial with those kind of lawyers involved. And I don't think Hank Brennan's doing any better than Adam Lawley did. Not from the outset. So we'll see. I don't know. I mean, I don't know if they can get a complete not guilty verdict on all 3 counts. I don't know. But I think they can hang the jury again. And if they do, is the state of Massachusetts going to once again invest millions of dollars in this case that they can't win? We'll see. I mean, I'd love to see an out and out not guilty, but we'll see. Hey, Susie, they've said as soon as they walked out of the jury room, people were shouting at them to look Lori up. Well, that makes sense. I mean, you know, that makes sense. People who were in the know. I mean, you know, not as if they wouldn't anyway. You know, I mean, they knew that there were cameras in the courtroom, so they knew that this was a publicized case, that she was a defendant everybody knows. So they would have anyway. You bet. The minute they got home, they would have been Googling it on the bus on the way home, or you know. And who can blame them? They just spent a chunk of their life and invested emotionally in Charles Vallow. They want to know what this woman's all about. So I think that's and completely understandable. So yeah. Yeah, Carol. I mean, I don't think that anybody who received the information about how Tylee was treated could feel anything but horrified and completely distressed. And I certainly think that someone who has invested emotionally in hearing a trial and making a determination is certainly going to feel that even more acutely than the average person. So yeah, no doubt. Yes, trigger warning. Um, Yeah, Carol, I see your comment. We're not going to put it up, but I agree. It, we all along, I mean, the reason I wrote the book was because it was so difficult to wrap my head around how these three people thought that what they were doing was okay, and how a mother does that to her own child. And so, I mean, I think that's the $1 million question. And it's the question that led me to write a book. And it's the question that keeps people coming back to true crime, is trying to understand what really amounts to the unfathomable. Oh, there was one other bit of information. Another of the Gilgo victims has been identified, which was good news. This was the woman and the child, somewhere around 2 years old. Their bodies were discovered quite a long time ago, and they were positively identified thanks to the FBI and their DNA and genetic genealogy units. So that is good news. Bittersweet news, but certainly good for her family. Yeah. Yes, she was an Army veteran. Yes, ma'am. I know. I know. Those cases that involve sisters in arms, they hurt my heart. They do. Oh, hey, Chelsea. I just understood the cited cases Stephen Cern's attorneys made yesterday in court, and I don't even practice law. Way to go. Well, I'm gonna take credit and say maybe people learn a little bit on LawTube, but Stephen Cern's, they did have a hearing. They're doing a motion to suppress to try and keep out the images. Now, remember, with Stephen Cern's, he has been charged with the murder of Madeline Soto, and he was her mother's boyfriend slash ex-boyfriend. She was 13, had just turned 13, and he also, when they took his telephone, they discovered, trigger warning again, thousands of images of SA, CSAM, as they're calling it now, where Madeline Soto was the victim and he was the perpetrator. And so he is now facing 2 trials. The first trial is for the SA and the CSAM. And that is because it is an aggravating factor. If he is convicted, it's an aggravating factor in the murder trial, and they are seeking the death penalty. So his attorneys, as you might expect, were desperately trying to keep the images that were found on his phone out. And so they filed a motion to suppress. They claimed that he had not given them permission, and they kind of went round and round, and ultimately they're going to come in. I mean, he gave them permission to look at his phone. He thought he had deleted everything. But as we well know, deleted doesn't really mean deleted. And so they were able to recover all that data. And so I don't believe there was a decision today, but because I didn't catch all of it, but I mean, any defense attorney would be making that motion, just like any defense attorney would be trying to keep the ARCA experts out of Karen Reed because it's bad for your case. Um, so, and zealously representing your client requires it. So, so they filed the motions, and I think they're going to go down in flames, and they'll move on. Although I did also hear that his case has been delayed. That the first case, the SA and CSAM case, was supposed to start next week, and it has now been delayed because of discovery issues or something. I don't know. Now they're talking about July, I think, is when the first trial will happen. Well, the prosecutor does not want to screw that up. The prosecutor does not want to rush ahead and risk that first case because it's an aggravator for the second case. So it's important that they do that in the right order and that they get a conviction. So they're going to protect that case, do whatever it takes. So. Why, thank you. It was so fun. I really enjoyed it. I've gotten to know Joel over the years. I met him at Crime Con, saw him again at the Tucson Festival of Books with his book about his mom. And he's a great guy. I like Joel a lot. I love his wife, Ileana, they refer to her as the COE, the chief of everything. And believe me, she is. All the time taking care of 3 little kids, but they're great. And I really enjoyed it. Joel invited me on initially to talk about Lori's trial, and then asked me if I would host the show on that Monday because it was Passover and they had the day off. So that was super fun. I got to do that. And I've been on a couple of other times since talking about Lori Vallow, and I told Joel I'll come on anytime he wants me. So you might see me again on STS when the Brandon Boudreaux trial starts. Now that trial is scheduled to start on May 30th. So we've got a little time, and Lori's got a little time to catch her breath and to figure out whether or not she really wants to be her own lawyer for this one, or whether she's going to ask her standby counsel to step in. She still could, but if she's going to, I really think she ought to be letting them know right away. So yes, I like Joel's guests too. He always talks about having best guests. He initially got involved in true crime because of the Donna Adelson case, because he's in Miami. And so he's been deeply interested in that. As a result, he's gotten to know a lot of people in Tallahassee and a lot of people at Florida State University, where Dan Markell was a law professor. And so he was very shaken by the recent shooting on the FSU campus. That was a pretty shaken day for him. And our hearts just go out to all of those people. And I don't know. I don't know the answer to these mass shootings. It's a frightening world. So take care of yourselves. Well, it looks like it's time for us to wrap up. If nobody's got any other questions, I do invite you, drop me questions or drop me emails if you have suggestions for other cases that you would like us to cover. I am definitely interested in the case of the Kentucky grandma who killed her grandchildren's mother, and visitation supervisor. That one's definitely on my radar. I'm really interested in Adelson, which is supposed to start pretty soon, and I'm all in on Reed. So I'm going to be covering those. But let me know if there are other things that you're interested in. I have a list of cases that I'm tracking to see when they go to trial, so we can talk about them, including Corey Richens. Now, Corey Richens' case has been delayed sort of indefinitely because she's got an interlocutory appeal. That's an appeal on a pretrial order from the court. Then, of course, we have Lori Vallow coming up with the Boudreaux trial. We have Crystal Rogers coming up in June. Her Brooks Hauk and Joseph Lawson, who are co-defendants, are on trial for her murder. She's one where they've never found her body. James Craig, the bad boy dentist, is coming up in July, as well as Larry Millette and Brian Cobberger. So we've got a busy summer coming up. As far as I know, Lindsay Shiver's case, the one in the Bahamas, is also coming up in July. So I'm keeping track of those, and we'll be talking about those once they come up. So, but do let me know if there are other cases you'd be interested in chatting about. With that, thank you for coming tonight. Thank you for those who managed to catch 2 nights in a row, and thanks for always being here. Please subscribe, hit the like button, and share the stream with your friends who might be interested in true crime as well. Thanks to Jennifer, who's always available whenever I need her, and who's always willing to jump in at the last minute. So I am going to say good night to everyone, and we will see you next Wednesday with another True Crime Wednesday.